The Espinoza case concerned a school choice program that the Montana legislature adopted back in 2015. And as originally adopted, it was open to all schools, religious or non-religious. But shortly after the program was adopted, the Montana Department of Revenue, which was the agency in charge of administering the program, adopted a regulation that excluded religious schools from the program, flatly prohibited parents from choosing religious schools. And they claimed that this regulation was warranted by the state's Blaine Amendment. As I'm sure your listeners are familiar, these are provisions found in many state constitutions, typically dating to the late 19th century. And they have origins that are steeped in anti-Catholic bigotry that was pervasive at that time. But nevertheless, the Department of Revenue claimed that this provision, this bigoted provision in the Montana Constitution, required the exclusion of religious schools. So we challenged that exclusion on behalf of three families, three moms in Montana who were eligible for the program and wanted to use it to send their children to religious schools. And we argued that to apply the state's Blaine Amendment to exclude religious options violated the federal Constitution and the free exercise rights of these three families. We won at the trial court, but then we lost at the Montana Supreme Court, which held that number one, the Blaine Amendment did require this exclusion of religious options, and that applying the Blaine Amendment that way to bar families from choosing religious schools was perfectly permissible under the U.S. Constitution and the Free Exercise Clause. So we appealed that decision to the U.S. Supreme Court. Thankfully, the court agreed to hear it. And in June of last year, June of 2020, the court issues this landmark decision in Espinoza. And it holds that to apply a state Blaine Amendment to exclude religious options from a program like Montana's violates the federal Constitution.